In Virginia, when two parents are unable to determine how they want to handle the custody of their children when they're separating, either parent can file a petition with the Juvenile and Domestic Relations Court for the city where they live and ask a judge to make the determination of how the custody of the child should be handled. Normally when that happens, the judge will appoint an individual called a guardian ad litem whose job it is to review the situation and make a recommendation to the court as to what they feel is in the best interest of the child. The overall principle that guides the judge in deciding what is best for the child is to determine what is in the child's best interest. Underlying that decision is a premise that both parents should be entitled to spend as much time as possible with the child unless there is some other issue that would make one parent a more suitable parent to have the primary physical custody of the child. One of the questions that I frequently get asked is, how old does my child have to be before they can decide which parent they want to live with for the bulk of the time? Unfortunately, there is no clear-cut answer to that, other than, of course, when a child turns 18, they're no longer under the jurisdiction of the court and can make a decision as to which parent they want to live with. But that's a different story than a custody issue. What the court will look at in deciding whether a child has a say in which parent they want to live with is the age and maturity level of the child. A child who is 12 but very mature may be able to state a preference as to where they want to live, where a child who's 14 or 15 may not have the maturity to be able to make a decision like that. Normally around age 14 is where the judges really start to consider hearing from the child, but they will hear from a child who is much younger than 14, and they may not take into consideration what a child who is older than 14 wants. Again, it will always look at what is best for that child. Many times parents are concerned about the issue of child support, especially when the child is splitting the time roughly equally between the two parents. And they want to say, well, if the child's living with both of us, why does either of us have to pay child support? But the issue of child support is separate from the custody, although it is a factor in how much support is paid. What is more important with the issue of child support is the income of each parent. If one parent makes far more than the other parent, they may still be responsible to pay child support even if the child splits their time equally between the two parents. So when you're looking at the amount of child support, you're going to be determining the total income between the two parents and then what percentage of that income each parent contributes. And then the parent is responsible for that amount of the child's support. Parents often ask me, well, how long is it going to take for this custody issue to be decided? This is really hard on us and it's hard on our children. Unfortunately, it can take a very long time for custody actions to be determined. Typically, you will have an initial hearing to see if there is a dispute over the way the custody is to be determined. If there is a dispute between the parents as to how they want to have custody, and the parents are not able to work that out through mediation or through some type of discussion, then the judge will set a trial date for it. It can be up to 6 months for that trial date to take place, and depending on what happens during that 6-month period, it could even be rescheduled or a second hearing scheduled if there are still issues that need to be resolved. And of course, the custody can always be modified if there is a change in circumstances up until the child turns 18.